The recording is started, sir.
Yes. So yesterday we concluded the definition of document: evidence, proved, disproved, not proved. Uh, so I've explained to you the nature of documents which are in the definition are limited. That is, the documentary evidence, which can be primary evidence, uh, which can be secondary evidence, and the documents illustrations given a map, caricature, inscription, limited. But the pertinent point to be noted in the for proving, disproving, and not proving definition, the court considers all matters before it and not just the evidence. Evidence के अलावा matters before it, everything is considered. Then the next definition, which is India. Of course, all of you know that now Jammu and Kashmir is a part of India by virtue of the present amendment. Then the next definition, which has been added recently in the year 2009, is certifying authority, electronic signature, electronic signature certificate, electronic terms, electronic record information, which are included in the Information Technology Act. This because all of you know that here the under the Information Technology Act, the material collected and whatever you are recording on the uh, on the your emails and Gmails and as well as the apps, they can only become evidence under Section 65A, 65B, for which purpose a certificate is required to be given by the authorities under the Information Technology Act, which we will deal with subsequently. It is the meaning of. So electronic record evidence is also dealt under the provisions of a Section 59, which tells you that by virtue of oral evidence, you cannot prove it. You require to prove it by the document itself which is produced and the certificate of the authority which is produced. uh, that is in cases of the original copy not available, email messages you want to prove, WhatsApp messages you want to prove, then you have to obtain the certificate of the information technology officer, um, that is as per the provisions of section 65B. Please note that. Then there are certain leading judgments in that regard. We'll discuss later on when it comes to yeah. Then the next important definition will start continuation in this in the Evidence Act, is may per section 4 3 to ho gaya abhi. Okay. Uh, the next section uses three expression: may presume, shall presume, and conclusive proof. Of course, merely just reading section 4 and these three are not enough. They are connected to various other sections in the Evidence Act and also the other provisions of the other legislation, which I will point out to you. Take, for example, may presume. So there are three types of, because the why there is a may presume here, because in civil cases, in the civil, yeah, in the first, let us first example take, in criminal cases the prosecution is required to prove a case beyond reasonable doubt, number one, and he cannot have any doubt. But in civil cases there can be some doubts here and there. The court, in the cases of doubts and increases, the court can iron it out. Hmm? The civil cases may evidence is led on the basis of a preponderance of possibilities, mean the court will think it is possible it may happen. So the court will draw inferences. It doesn't mean it doesn't mean that the court doesn't draw inferences in criminal cases. Yes, when circumstantial evidence is required to be considered, the court always draws inferences. तो यहाँ पे section 4 में the court presumes mean, may presume mean, when a document is tendered by you in the court of law, it may be a 30-year-old document. Yeah, the author is not available. So normally the court may presume it's a genuine document. It is the discretion of the court. But the may presume discretion which the court is giving, that can be dislodged by the other side by proving that here it is in fact a forged document. And because this document has been declared illegal in a previous proceeding. This document has been declared as a forged document in other proceeding. that you will need evidence before the court of law. So I will take you through, because the illustrations with regard to section 4, let us first read what is may presume. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. So here an opportunity is given to the plaintiff first. Prove this fact that you have posted this letter, that this termination notice is gone to your tenant under section 106 of the Transfer of Property Act. लैंडलॉर्ड बोलेगा मैंने नोटिस दिया था, I have dispatched it to the post office. Isn't it? Or under certificate of posting, or through the hamdast of my clerk, or the summons have been sent to the Sheriff of Bombay, who is the authority under the exercising powers under Order 5, read with section 27 of the Code of Civil Procedure, or a concerned police station who are responsible for sending the writ of summons or executing bailable, non-bailable warrant under the CRPC. So the court may presume that this particular official duty may have been discharged. So the court may, suppose you have sent the registered AD, letter वापस नहीं आया है आपका, so you may tell the court, my lord, this is the acknowledgement. This is the letter which I sent from the GPO Mumbai or GPO Calcutta, Madras, wherever it is, and they have given me the receipt. So normally the court will say that the receipts which have been issued by the postal authority, the court may presume is genuine document. So the court may draw a presumption under the General Clauses Act. For example, under the General Clauses Act, आप कभी सुन चुके हैं, वो section 27 है. Last time I think I wanted to you. The court may presume that yes, ये letter पहुंच चुका होगा. You have dispatched the letter from the Government Law College red box which is there. The postman or must have collected it. So the court may presume it has been sent. But the other side, your licensee or a tenant may lead evidence to show that मुझे कोई letter मिला ही नहीं. My address is different. It is not so. I was not in Mumbai. I was not in India. It is a fiction, because the letter of termination of your tenancy is a very valuable letter. Because if your tenancy is determined terminated, your rights, you can be evicted by virtue of the proceeding that may be filed. So it's a serious matter for you. So when the landlord has filed a proceeding and tells the court, yes, I given notice under 106, it was sent by post office, the landlord's burden get discharged, he produces the acknowledgement. पहले CPC के अंदर there was a Order 5 Rule 19A where the court can draw a declaration, yes, the letter has been dispatched. Order 5 Rule 19A has now been deleted. Now, section 27 of the General Clauses Act is still there. That you can, those of you can see that, you can display it, Kumar, if you get time. General Clauses Act, section 27, where the court draws presumption. So the court will presume that yes, the act has taken place. The court may say that the plaintiff has taken the plea that there is a custom in the community of the plaintiffs to take in adoption a child above the age of 15, 16-year-old. समझे ना? So a senior man is examined from the locality, a very senior person, 85, 60, 90-year-old. The court may presume that such a custom must have existed. unless the other side dislodges. So it is stands proved, not proved, disproved के अंदर. But merely the court, because the evidence ने plaintiff ने lodge किया है, it doesn't become a gospel truth. Please note that the defendant will be asked, called upon to lead any evidence. Number one, you will cross-examine. Cross-examination में you will lead evidence in rebuttal to prove that ऐसा कोई लेटर मिला नहीं मुझे. Number one, आप गलत बोल रहे हैं, आपकी जबानी, your statements are incorrect. In fact, the defendant was not in India at the relevant time and you have not dispatched it. And you also taken care to issue witness summons निकालेंगे आप कोर्ट को, बोलेंगे I would like to examine the post office. You may take up the plea that a fraud has been played. Under the provisions of Order 16 CPC, you will take out application that this honorable court be pleased to issue witness summons upon the post office. The concerned police, the GPO Mumbai, be directed to send the files and the concerned postal representative who allegedly delivered the letter. उसको आप cross examine करेंगे, or you lead evidence. You have a right to do that here, or both the parties can prove that here. So यहाँ पे prove होता है. Now the illustrations with regard to may presume, you have to see 114 of the Evidence Act and also other provisions. I'll point out section 114 खोल लीजिए आप. These are called natural presumption. May presume, where the court draws inferences. So please open your 114 of the Evidence Act. I will give you illustrations. You will understand this may presume more so from this year. 114 खोल लीजिए. So you got it? Court may presume the existence of certain facts. मिल गया आपको? Section 4 से directly आया 114 ना? Please record it and याद रखिए आप. So the examples of may presumes are given in 114. If you remember this, then nothing like it. Number one, the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events. Number one, human conduct. Number two, and public and private business in relation to the facts of a particular case. So there are four circumstances which are listed in this section 114. इसके ये सब समझ में आएगा आपको only with the help of illustration. Now let us see the illustration. We try and cover the all illustration here. Number one, both on civil and criminal law made is there. Number one, the court may presume that a man who is in possession of a stolen good after the theft is either thief or has received the goods knowing them to be stolen unless he can account for the possession. So this is directly under the criminal law. Indian Penal Code में आएगा. Receiver of the stolen goods पढ़ चुके हैं आपने. Section 401 के अंदर वो an offense है वो. Isn't it? Theft हो गया, चोरी हो गया. And many people keep the चोरी करके jewelry वगैरह. They go to the jewelry market में and mortgage and take money. Sell it and take it money. So यहाँ पे the man in possession of a stolen good. So you lodge a complaint with the local police station while traveling in the train. Somebody came and snatched your phone. तो ये अक्सर होता है. Or you are traveling in a rickshaw from your residence to your college. While you are having a talk and two people came on the scooter, they snatch your mobile phone as well as your briefcase or your, if you are a girl, a woman, your bag which was contained. So you lodge a complaint with the police station. So police station is arresting somebody who is riding the bike. So the police officer will ask him, please explain ये मोबाइल फोन कहां से आया आपको, किसका है, produce the papers. If he is unable to produce the papers, the court, the police officer can presume that he has stolen the article. It's a stolen article and he's a thief. Number one, he's a thief or he has stolen it, or he's a receiver. Suppose the gentleman who snatched it from you goes and sells it to some in the market. कोई किराना शॉप में जाके बेच दिया, 10,000 का मोबाइल इसको मिल गया 2,000 रुपए, he is happy with 2,000. So the police has a record of the people who purchase this stolen material. Police has got full record. Police को सब मालूम है. आपकी गाड़ी भी चोरी हो गई, parts भी निकल गए. So you lodge a complaint, FIR. Police को मालूम है ये area में so and so people. Ask him, show me the papers of these articles which are in your possession. If he is unable to produce, of course, he will be arrested by the police officer. Number one, under section 41 CRPC. You know that the police officer cannot detain him for more than 24 hours as per the language of Article 22 and section 57. He will produce him before the magistrate under section 167 to CRPC. So he will apply for a bail under section 437 के अंदर. Application for bail के stage पे magistrate will ask him, this is a stolen article to be recovered. Please condition डालेंगे आपको कोर्ट को. Please explain how did you purchase it, where did you purchase it. So this is the interlocutory stage of bail. Basically, this will come at this issue of trial. So if you are not in a position to explain at the stage of a trial that this is you have purchased it, the court will presume that you are a chore. You have stolen the article, so the court presumption. The court will presume it, but that presumption can be rebutted by the person showing that the allegation of the police officer or the complainant are totally false. I have purchased this mobile phone in Dubai, Singapore, on so and so dollar. I will call for the bill which has been misplaced. So अगर कोर्ट में लाके प्रोड्यूस करेगा वो, that is called evidence in rebuttal you are leading. So the other side will disprove the case. क्या? So the plaintiff, the complainant and the prosecution is trying to prove the case. The proved, disproved, not proved. So the court will consider the existence of several matters at this stage. Number one, the article in possession and explain. Bombay Police Act के अंदर section 124 है. So many people are selling hawkers वो उनके सामान लेके चले जाती police. So all of them are required to account here, give details कहाँ से लिए सभी. If they are unable to account for it, it is confiscated. So when the accused person leaves a believable evidence, that is called rebuttable evidence, then the presumption can be discharged, will not be held. Otherwise, the court will presume, yes, you are a thief. समझ में आया? Anybody this? Anybody has any question, please ask me. So this is the meaning of here. Both the parties, the first court will say that court may presume. In the government law college में one of the student may say मेरा mobile phone disappear हो गया, मेरा diamond rings disappear हो गया. So you come and report to the principal or to me or the lecturer, whoever is there, you may lodge a complaint, isn't it? The police, of course, there are many aspects to it. Announcement is made, the police is coming to look out for a person who has stolen the article. You may run away, go away from here. That will be one of the evidence which can be led. There's a matter before the court. No sooner the lecturer made the announcement in the college, student XYZ got up and left the college. Classroom छोड़ के भाग गया. डर के मारे के पुलिस पकड़ेगी उसको. That evidence can also be led. Please note that it is a evidence leading to his conduct. The motive, preparation, conduct, that is also then the court may presume that he is a person. The reason why he left because he is guilty. समझे ना? So the court may presume, why did you leave? Number one. Number two, police पकड़ी तुम्हारे पास जेब में निकला है मोबाइल है. You please explain. Number two, you are not able to produce the documents relating to purchase of the document. Number two, so I go बोलेगा, give me time. I have to go home and find it out or check it out. So if he is given opportunity, which opportunity he gets, if he brings the documents and successfully press that, yes, I have purchased it from XYZ place, then court will not draw the presumption against him. Otherwise, the first hand initially pursuant to a complaint, having regard to his conduct, leaving the place and going away, unable to explain how the article was purchased by him, the court may presume he is a thief. समझ में आ गया आपको ये बात? नहीं आ गया? नहीं? Yes or no? Let me, I will just close my, is it my fault? Is it my phone or somebody's phone?
I believe it's your phone only, sir.
I will ask my wife to close it. Give me 1 minute, sir. मेरा फोन बंद कर दीजिए प्लीज. नाजिश, फोन दो. कहां बजा? मेरा फोन निकालो बेटा. I don't know. So this illustration is okay? समझ में आ गया आपको? नहीं?
Yes, sir.
Yes. Number
Yes,
two,
sir.
देखिए. That an accomplice is unworthy. That an accomplice is unworthy of credit, or नहीं, of credit, unless he is corroborated in material particulars. Now, accomplice कौन है आपको मालूम है ना? Isn't it? CRPC के अंदर सीखे हैं आपने? Isn't it? Anybody remember the accomplice? Section 306 में है ना? Isn't it?
Yes, sir.
An accomplice is actually an accused person. He is given pardon by the magistrate. Isn't tender of pardon to accomplice? Mean a person jointly committed the crime. Isn't it? Somebody, just my phone is ringing. I just want
Give
to.
me this thing.
This one is. हमारा phone भी निकाल.
Phone को silent कर दो.
Yeah. So an accomplice is a person who is jointly committed the crime. When the police investigating the crime unable to unearth any material, because they are seasoned killers, document नहीं मिल रहा है, evidence नहीं मिल रहा है. There may be 2-3 accused person in a conspiracy like bomb blast cases. Now in the murder of that girl, Sheena murder case, Mukherjee's family, isn't it? The mother has strangulated the daughter with the help of her husband, who is the stepfather, and the driver Rai has confessed to the crime. Mother and father not confessed it. So the magistrate gave him pardon under section 306 CRPC. So he became an accomplice. So यहाँ पे under the provisions of the Evidence Act, an accomplice normally he supports the prosecution. He will not be supporting the defense, although he was an accused. When pardon is been given to him under the law, he will become the witness of the prosecution. Police का witness बन जाएगा वो. So the law कहता है his evidence should be taken with a pinch of salt. Why? Because he himself was implicated. But the magistrate is giving him oath, pardoning him under 306 on a condition, number one, he will truthfully depose the matter. He will give best evidence possible. Possible nahi. He has to give the best evidence and the truth and not suppress anything. And he should not mislead the court. अगर कोर्ट को मालूम होएगा कि he, despite having taken the advantage of a pardon under 306 CRPC, he is supporting the defense, the magistrate can withdraw the order and try him as an accused. So he will not be tried as an accused, he will be a star witness for the prosecution. Now the CRPC, the Evidence Act, it says accomplice is unworthy. So ये section कहता unworthy, his evidence cannot be taken seriously, should be only accepted when corroborated. Mean his evidence on the sole testimony of the gentleman, conviction should not be based. So in the Sheena murder case, the prosecution is leading the evidence of Rai, who is the driver of the Mukherjees, and he is supporting so far. But as per the language of this section 114 clause B, prosecution should not solely depend upon his evidence alone, and his evidence needs corroboration. Now, what is corroboration? Corroborative evidence? Additional independent evidence. Please note that. वो additional independent evidence कहाँ मिलेगा आपको? Section 156 खोल लीजिए. How do you get corroborative evidence? Question tending to corroborate evidence. Please open 156 of the Evidence Act. When a witness whom it is intended to corroborate, mean give evidence to support, gives evidence of any fact, he may be questioned as to other circumstances which he observed at or near the time or the place at which such relevant fact occurred. If the court is of the opinion that such circumstances, if proved, could corroborate the testimony of the accused, of the witness also. So the witness, the gentleman driver, comes and gives evidence before the magistrate or sessions judge. Yes, I am the driver of the Mukherjees. I went along with them in the car. From their residence in Bandra and Pali Hill, we picked up their daughter from a college in Bandra in the evening 5:30 p.m. and we proceeded towards the farmhouse which is in Panvela, Pen. In the journey while going, the mother and her husband, who is the stepfather, strangulated the girl and told me also to hold her feet, which I did. Her dead body was taken and in a jungle in Pen area, we burnt it. That is the statement. That is the unfortunate story of the daughter who was killed by her own mother. So because the murder was taken place long time ago, 4, 5, 6 years ago, kahan jalaye body, and it is not so easy to locate the skeleton parts. Kuch na kuch mili police ko. So they have sent it for a chemical analysis, a DNA test, all these chemical tests which are required to be done. And there's a confession by the gentleman driver in this regard. Now the master, the mother and the father say that the evidence is not reliable of the driver. So that needs corroboration. If the prosecution want to convict them, they need corroboration, mean independent witnesses. Please note that the meaning of corroborating mean proving a case with the help of independent other witnesses to support the case of the prosecution or defense. That is permissible under 156. Then only a court will draw the presumption that the rise evidence driver is only acceptable provided it is corroborated by the evidence of other witnesses. That is what? Otherwise, court should not presume that his evidence is correct. इसका मतलब ये है. इसका contradiction एक है, मैं बताता हूं. 114B is fine. The court may presume that an accomplice evidence can be taken subject to corroboration. But there is one section in the Evidence Act which takes a slightly different view when there is a good evidence and believable evidence of the gentleman under 306 who has been declared a co-accused, what you call it, accomplice. An accomplice is a gentleman and he is believable witness. Uska evidence ke liye you don't require corroboration. That is given in section 133 of the Evidence Act. खोल के देखेंगे आप, मालूम पड़ेगा. 133 दा खोल लीजिए, इसके अंदर मैं बताऊंगा. 133 says that, please remember this because we don't have to repeat the section again. Accomplice, see 133 के अंदर 133, an accomplice shall be competent witness against an accused person, and a conviction is not merely is not illegal merely because it proceeds upon the uncorroborated testimony of the complainant. So यहाँ पे totally a different scenario. एकदम the Evidence Act is taking a somersault here. 114B में कहता है कि accomplice का evidence is not very good unless it is corroborated. 133 कहता है कि without corroboration also the court can convict if the evidence of the accomplice is very good. So that means a discretion is given to the court. A judicial magistrate or a court of session or a high court judge who is conducting a trial, उनको इतना heavy responsibility दी गई है. You decide it whether should I accept or not. So appreciation of evidence is in the hand of a trial judge. So he will have to weigh whether I should follow 133 or whether I should follow 114B. So that it depends upon the demeanor of the witness. That depends on the witness, whether he is a truthful witness or not, whether his deposition was candid or not, whether it was a frank witness, a witness who has not been tutored. There are many tutored witnesses. It is the job of a trial court to give a finding in this regard. Please note that here. 114B is directly in contrast with section 133. And please note that when there are more than 2 or more witnesses, you have learned in the CRPC, they may be a joint trial of the witnesses. Joint trial, isn't it? There has to be a joint trial. There is no bar. That 216, 17 check करें यहाँ पे CRPC के अंदर. (221) check करें यहाँ पे. Sorry, joint trial is starting from 218, 19, 20, 21. These illustrations you should remember. I'm not reading it out now. CRPC के जब कहते हैं. So a joint trial is contemplated when there are more than 2-3 people. But a confession of a co-accused is acceptable under the Evidence Act only when they are tried jointly together. उसके लिए please section 30 check करो आप. 30 of the Evidence Act. So when is he implicating? When can he implicate the other party? When his evidence can be accepted. See that 30 checker up. Consideration of proved confession affecting person making it and others jointly under trial for the same offense. Underline the word jointly. Court will only accept the confession of a co-conspirator provided he admits, yes, I am involved in this matter. Huh? A was killed by me and by Mr. C. So Rai must admit here in before the court, yes, Sheena was murdered by parents, her mother and me. But he cannot say मैंने नहीं मारा, उसमें भी मारा उसने. He was involved. He is one of the joint conspirator in the matter. Then only the confession will be accepted, provided there is a joint trial on the same offense. उसके लिए illustration I'll tell you. When more person than one are being tried jointly for the same offense, take for example murder, and confession made by one of such person affecting himself, he must concede कि मैंने participate किया crime में, affecting himself, and confession made by of such person affecting himself and some other such person is proved. So along with me, Mr. B also was there in the crime when we have committed the murder of Mr. A. Then the court may take into consideration such confession as such other person as well as the person who made the confession. Then only the confession is accepted. That is the normal procedure. But यहाँ के अंदर 30 के अंदर, if one of the person has been given pardon, mean though there is a joint trial, he is being tried as the prosecution witness. The illustration to section 114b will come into play, which says that his evidence cannot be accepted without there being corroboration. But 133 says, yes, there is no bar. Court has power to accept the evidence of the co-accused or of the evidence of the accomplice without corroboration. That is 133. ये दोनों जाना जरूरी आपको. Please pay attention to this. Very important topic this is. And section 30 में there must be a joint trial. In other cases, अगर वो confession accept करने का है उसको, impleading the others, there must be a joint separate trial में नहीं हो सकता. Suppose the accomplice having been granted permission by the magistrate under 306 CRPC and he backs out, magistrate will tell him, no, you are not fit for the being granted, you are not opening up yourself and not giving correct evidence, I am withdrawing the permission granted to you, you will not be co-accused. Uske baad, you cannot be tried, he cannot be tried jointly, he has to be tried separately. Please note that you cannot be, because he should not be prejudiced now. अगर jointly करेंगे तो उसको problem आ जाएगा. That situation I'll explain to you. वो 309 में 306 में भी लिखा गया है. तो यहाँ पे any evidence of a co-conspirator is to be accepted, there must be a joint trial. And in the joint trial, he must implicate himself. मैंने crime किया और मेरे साथ में Mr. B ने किया, मेरा companion था. Then it becomes, see the illustration, मिल जाएगा. A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C. The court may consider the effect of confession of guilt. So दोनों भी जाएंगे, because the joint trial held, he is pleading. Now illustration B check करो. A on his trial for murder of C, there is evidence to show that C was murdered by A and B and C. I murdered C. This statement may not be taken into consideration against A. B is not being jointly tried, a separate trial. So this is not admissible. So you should know the meaning of a joint trial, reading section 217, 28 NCPC, and when a person is a accomplice, reading the provisions of 306 of the CRPC, 300 tender pardon to accomplice. Now वहाँ पे 30C में clearly लगा गया है, there are circumstances, see that here, with a view to obtaining the evidence of any person. Please pay attention here. Now this is directly attached to 114B. With a view to obtaining the evidence of any person supposed to have been directly, indirectly concerned in or privy to an offense to which the section applies, the Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation or inquiry into trial of the offense, and the Magistrate of the first class inquiring into trying the offense at any stage of the inquiry or trial may tender pardon, underline this word, tender pardon to such person on a condition of his making full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as principal abettor in the commission of the offense. He must make a clean breast of the situation. मैंने क्राइम किया है, मेरे साथ में ए एंड बी ये तीनों थे, शीना की मम्मी भी थी, इसके डैडी भी थे. That is the first condition. Number 2, this section applies to any offences triable exclusively by the court of session or by the court of special judge appointed under the criminal law amendment. This section applies to session triable cases. Please note that here. This cannot go to the magistrate. Of course, is giving sanction to prosecute him for offense triable by the court of session or under the criminal law, any special offences, NDPS Act के अंदर. शेड्यूल ट्राइब शेड्यूल कास्ट ऑफेंसेस के लिए वहां पे एक दूसरे को गाली दिया. एनडीपीएस के अंदर and many of them have arrested the authorities on possession and sale of the act. Then B, an offense punishable with the imprisonment which may extend to 7 years with a 7 more. तो यहाँ पे 7 years an offense punishable है, तो court of session लेगा. Then every magistrate tenders the pardon shall record his reason for doing so. Number 1, tender was not accepted by a person to whom he was made, and record the cause. Every person accepting tender pardon under this section shall be examined as a witness. Underline this word. He shall be examined as a witness in the court of the magistrate, taking cognizance of the offense and in the subsequent trial, if any. So यहाँ पे at the stage of giving pardon under 306, though the offense is triable by the court of session. आप बोलेंगे court of session का रहेगा तो session court में इसको क्यों trial नहीं हो रहा है? Why is he not deposing there? But the function of tendering pardon is delegated by the legislature to the judicial magistrate, metropolitan magistrate, and not to a court of session, because this is given to a inferior judicial officer, because he will be for A reason, B reason, because maybe session court judges are more busier with heavy matters. Because a magistrate cannot try offences more than punishable for more than 7 years, isn't it? Life imprisonment hoga under the various enactment he can give, but maximum punishment he can give 7 years. So इसीलिए वो function magistrate को दिया गया. Even the evidence will be recorded by the magistrate. Please note that here. You must read section 114B and 133 read with 306 of this evidence. Then clause B, shall, unless he is already on bail, be denied, be detained in custody until the termination of the trial. So he will be normally granted bail or not granted bail. If he says my life is in danger, the magistrate may choose to keep him in special custody. Because मुझे उड़ा देंगे. There are gangsters involved. He is going to depose against influential people, industrialists and gangsters. अरे पुलिस से हाथ मिला दिया इसने, हमारे खिलाफ हमारी वाट लगा देगा. That is what the statement the people will say in Mumbai and elsewhere. So he will be kept in a safe custody. He may choose not to come on bail, or he may choose to be isolated. That is the reason here. Then item number 5 check kare, where a person has accepted tender or pardon made under subsection 1 and has been examined under 4, the magistrate taking cognizance of the offence shall, without making any further inquiry in the case, commit it for trial. So a committal सीखे आपने under the provisions of section 209 के अंदर, when the charge sheet is filed before the magistrate under the provisions of 173, the magistrate transfers the case to the court of session. That is called committal proceeding. So before committal proceeding, this evidence is recorded by the learned magistrate of the gentleman who is a accomplice, who is a partner. Please note that. Ye bhuliye mat ga. Then committal for trial, item number 2, to the court of session if the offence is triable exclusively by the court, or if the magistrate take cognizance of the chief judicial magistrate, to the court of special judge appointed under the Criminal Law Amendment Act. In any other case, may make over the case to chief judicial magistrate, who shall try the case himself. So यहाँ पे 3 options दिए गए हैं. So the court of session, because this section is applicable to offences triable exclusively by the court of session, where number 1, number 2, or by the court of special judges appointed under the Criminal Law Amendment Act, such as NDPS Act, Customs Act, Anti-Corruption Act. तो वहां पे ट्राई करेंगे. All the functions can be delegated by the High Court even to Chief Judicial Magistrate. Transfer powers are given to you. You know that under section 406, 407 CRPC, and the courts have power to transfer the case from A place to B place. So these are the. Then 307, power to direct tender of pardon. See, when we read section 114, power at any time after the commitment of a case but before the judgment is passed, the court to which commitment is made may, with a view to obtaining the trial, the evidence of any person supposed to have been directly, indirectly concerned on any privy to any such offence, tender pardon on the same condition to such person. So this is what the magistrate does it here. He tenders pardon and asks him to give evidence in favor of the prosecution. Then 308 कहता है, when he is not supporting the prosecution. Let us see 308 देखिए. Trial of a person not complying the condition of pardon, where in regard to the person who has accepted tender of pardon made under 306, 307, public prosecutor certifies that in his opinion, such a person has either willfully concealing anything essential or by giving false evidence not complied with the condition to which tender was made. Such a person may be tried for the offence in respect of which the pardon was tendered, for any other offence of which he appears to have been guilty in connection with the same matter, and also for the offences of giving false evidence, perjury under 191, 192 of the IPC. Then important thing here, provided that such a person shall not be tried jointly with any other accused. Please note this. Section 30 में पढ़े आपने, उसका confession will only be accepted implicating the others, provided there is a joint trial. अगर if he is not supporting the prosecution, his evidence will be separated. That means he will not be allowed to, he cannot be tried along with the other accused because the defense will object. This man is disloyal to us. क्या बोलेंगे? He is a police का supporter है, police का spy है ये. He should not be tried with us. The defense of the accused will be prejudiced. Rightly, the parliament said that the man who, having accepted pardon under 306, 307, and he has backed out and not supporting the prosecution, isko wapis chalao case, but not joint trial. Section 217, 218, 9, 10 CRPC cannot be invoked. Let there be a separate trial. That means whatever confession this man makes subsequently is of no use. He is an unreliable witness. So he will be isolated in the trial. Next, see that. provided further that such a person shall not be tried for the offense of giving false evidence except with the sanction of the High Court, and nothing in the section 195 340 shall apply to the offender. तो यहाँ पे झूठ बोला गया मजिस्ट्रेट के सामने कि मैं सपोर्ट करूंगा, प्रोसिक्यूशन को नहीं किया है, तो उसके लिए he is committing perjury, which is an offense under the provisions of a section 191 192. अगर 191 192 कोर्ट में झूठ बोलता है नॉर्मली, उसका प्रोसीजर क्या है मालूम? Under 340 CRPC, that is called offenses affecting the administration of justice. Suppose if you are given evidence in the High Court or in the Court of Session or in the any other court, वो कोर्ट ही क्या नाम कंप्लेनेंट बनेगी. You cannot become, I cannot take proceeding, you cannot take proceeding, or any of the co-accused cannot file proceeding. Only the court or the judge of that particular court will issue summons to him after holding an inquiry under 340 CRPC. I think हमने पढ़ाया था, you may be remembering, you may recap it in memory. So it is only when the court where he has committed perjury comes to the conclusion that इसी आदमी ने झूठ बोला है ओथ लेके, start proceedings against him, the court will give sanction. Then the registrar of the court in the Bombay High Court, Protonotary Senior Master High Court Bombay original site, अगर appellate side में तो normally अगर झूठे बयान ही दिया है तो registrar in the court of session, registrar magistrate court में the registrar will file a separate complaint. The separate High Court will file a complaint if the evidence is given. And give it to them. That magistrate will file before the Chief Judicial Magistrate in Bombay at Esplanade and Kila Court. Kila Court के अंदर in Bombay में, other places in district area it is the Judicial Magistrate. Delhi के अंदर is the Metropolitan Magistrate. So that is how they remember that here. Perjury action के लिए, whereas in the case of an accomplice who is committing, accomplice 340 dispense with. So there is no need to go to that court and take sanction. लंबा चक्कर है, inquiry करने की जरूरत नहीं. And he has spoken, he has lied to the magistrate that I will support, but the public prosecutor giving a certificate instead of, he is not willing to support despite having taken tender pardon. उसको माफी दिए हैं, बेल पे भी आ गया है, घूम फिर के एंजॉय किया लाइफ है 2 साल के बाद 3 साल के बाद. When it comes to recording evidence, he is supporting the accused person. So he's जो original protection withdraw करेंगे उसको, then he will be tried separately as a co-accused. And of course perjury भी होएगा. Perjury में 340 का procedure नहीं लगेगा. 340 is a cumbersome procedure. CRPC घर पे जाके check कर लो आप एक बार. Only the court can become a complainant following a procedure under section 195 CRPC. Who can file? In the case of contempt of lawful authority and for perjury and for a conspiracy of certain offenses, only the court is competent to file a complaint and not any Tom, Dick and Harry. You cannot file, I cannot file it. Then next, any statement made by such person accepting the tender of pardon record a magistrate under 164, court under section 306 may be given an evidence against him at this trial. So उसके क्रॉस एग्जामिनेशन में बताया जाएगा कि look here, you had made a statement before the learned magistrate under 164 confession accepting your crime. अभी यहाँ पे झूठ, वहां पे अलग बात कही आपने और यहाँ पे झूठ बोल रहे हैं आप, because his own evidence will be used against him under 164 and 301. So that law permits even under the Evidence Act, when you see section 33 tells you the evidence of any person against him can be used in A proceeding, B proceeding. Just open 33. Relevancy of certain evidence for proving in subsequent proceeding the truth to facts remain stated. So Evidence Act in section 33 permits the evidence of a person in other proceeding, maybe civil proceeding, maybe criminal proceeding, court of session के अंदर, वो section 33 को याद कर रही है आप. So how this law is connected, see, I am taking you from section 4 से लेके section 14 से लेके 133 से लेके 306 CRP से लेकर and coming back to 33. Please pay attention because that is the route you will be traveling as a lawyer in the court of law. यहाँ पे how, because this section is telling you his statement can be used. I am explaining you under 308 subclause 6, he can be subclause 2 में he can be contradicted can by using his statement under 164 and 306. Uska provision hai section 33 of the Evidence Act. The court will now. I told you also another thing. The evidence given by one witness in the Commission of Inquiry Act under section 6 cannot be used in any other proceeding. That is the only bar. Similarly, under the conciliation proceeding, under the Arbitration Conciliation Act section 75, all proceedings which are conducted by the conciliator are confidential. That cannot be used in any proceeding. Please note that. ये सब चीजें जानना जरूरी है आपको. In the longer run, maybe as a student, I do not know, some professor who is an intelligent man, he may quote this question, or practice में आपको आएगा question ये. Item number 3 पे आ जाइए. 408 at such trial, the accused shall be entitled to plead that he has complied with the condition, and such a tender was made in the case shall be for the prosecution to prove and not the complied with. So the onus is to prove upon the prosecution that he has not complied the terms and condition. He has taken a somersault, but not upon the accused. The onus is not shifted upon him. So then at such a trial, the court shall, in the court of session, the charge is read out and explained to him. Number B, the magistrate evidence witness so and so. Then the accused does plead it. The court shall record the plea and proceed with the trial and pass judgment in this matter. So this much is the rigmarole in a tender of pardon cases, which is very cumbersome procedure. That is why the court is saying Evidence Act 114 भी कहता है कि इसका evidence को don't take it with a pinch of salt. You require corroboration. It is the meaning of 114B. Please note that here that the accomplice is unworthy of credit. तो आदमी पलटी मार के आया है इधर, उसके एविडेंस के ऊपर क्या भरोसा? Why you want to give him? इसीलिए unless corroborated, corroboration, please remember the section of corroboration, section 156 of the Evidence Act is used for corroboration. इतना याद कर लीजिए आप. Okay, so these two are now clear. Anybody wants to have any doubt, please ask me before I proceed to the next one. C. कोई doubt है किसी को? Anybody has any doubt? नहीं? Now come to C. Third illustration 114 का, that a bill of exchange accepted or endorsed was accepted or endorsed for good consideration. So the earlier two illustration related to the criminal cases. Now this is a commercial transaction in a civil case. The bill of exchange accepted, endorsed was accepted or for a good consideration. उसके लिए the court may presume that आपने जो बैंक से पैसा बेचा था मिल चुका होगा. You please open 118 of the Negotiable Instrument Act, कुमार. देखता हूँ मैं, मेरे पास है क्या Negotiable Instrument Act? Yes, मेरे पास है, आप भी इसको लीजिए. I don't know who is troubling me. I don't know where is my phone. Where do I find this phone? Can you give me how to disconnect this phone? मेरा फोन कहाँ है? प्लीज मामा ने चेक करो. प्लीज आइए. Don't do that. फोन दीजिए मेरे को. Sorry, my phone is in the other bedroom and is making
Sir,
noise.
which section of Negotiable Instrument Act?
सेक्शन पढ़िए आप. 118 खोल लीजिए आप. 118 खोल लीजिए. 118 के अंदर बताऊंगा आपको. प्रिजम्पशन एज टू नेगोशिएबल इंस्ट्रूमेंट एक्ट. 118 भी खोल लेंगे, 139 भी खोल लेंगे. There are two beautiful presumptions under the Negotiable Instrument Act. For civil lawyers and lawyers who want to specialize, and I am against the word specialization, but you should do all the laws, including the Negotiable Instrument Act, CPC, CRP. देखिए 118 पढ़ लीजिए आप. 18 कहता है presumption as to negotiable instrument, unless the contrary is proved, the following presumption shall be made. See, this is like 114 के अंदर. Consideration that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated, transfer, was accepted or endorsed, negotiation for consideration. So अगर दुबई से आप माल भेजें, मैं आपकी बैंक से चेक भेजा हूं, कंसाइनमेंट आ गया, समझो पेमेंट मिल गया आपको. Isn't it? Without receiving, you will not pay it. That is how it is. Then as to date, every negotiable instrument bearing the date was made, drawn such date. As to acceptance, some bill of exchange. 118 का पढ़ लीजिए आप, please, important. Then come to 139 also. Section 139. 139 says, Negotiable Instrument Act, presumption in favor of a holder. It shall be presumed, unless the contrary is proved, that the holder of a check received the check of a nature referred to in 138 for discharge of the whole or part of the debt or other liability. Suppose if I owe you money, and I have given you a check which you have deposited in your account, it is presumed that the amount has been discharged. So the court may presume that the amount has been paid. अगर हुंडी एक्सचेंज किया है, if I sign some instrument with you, a loan agreement, you took my signature, or a mortgage deed, आपने original deed आपके पास है, मैंने पैसा लिया आपसे, then ultimately original deed आपके कब्जे में आ गई, the mortgage is discharged, isn't it? So the court may presume. So presumption under the यहाँ पे bill of exchange is duly endorsed for consideration. तो पढ़ चुके हैं आपने. This I don't have to tell you this. Number 2, understood this? Anybody? Any problem? Let me know. Number D, that the thing or a state of thing which has been shown to be in existence within a period of shorter than that within which such thing the state of thing usually ceased to exist is still in existence. So something which was in existence, इसका meaning हम समझेंगे पढ़ के ये illustration, that a thing or a state of thing which has been shown to be in existence within a period of shorter than that within which thing the state of thing usually ceased to exist is still in existence. So कभी this example can anybody give me an example on this? I will give you an example on this tomorrow. Give me. Yeah. That a common course of business has been followed in a particular cases. Common course has been taken in a particular case. उसके illustration check करेंगे आप. What is the time, Kumar? 114 C देखता हूं मैं, बताता हूं. What is the time now?
It's 6:40 p.m.
हाँ जी.
6:40 p.m.
6:40. Another 5-10 minutes ले सकते हैं, because I have a lecture for Delhi students.
Okay, sir.
एक मिनट. फोन आके डिस्टर्ब कर दिया मुझे. Yeah, permit me to take up these other illustration tomorrow. Tomorrow mean when are you meeting? Other illustrations I will take it in another lecture, because I have other commitment. I have forgotten.
Tomorrow or day after tomorrow?
Day after tomorrow. I mean tomorrow का मतलब day after tomorrow.
Yes.
Friday का दिन can you give me little early?
5:30 p.m.
No, उससे जरा जल्दी कर सकते हैं, possible है, morning में, दोपहर में.
What time, sir?
Can you give me some different time?
Sir, we can do it after 11 a.m. in the morning.
After 11? I will tell you by tomorrow, because after attending the court matter, I will tell you. After attending the court matter. Please confirm.
Okay,
Friday
sir.
Friday
Okay,
ka
sir.
din
We
I'm
will
leaving at 3 o'clock
coordinate.
to my farmhouse because some urgency has arisen then. I could have continued today now because unfortunately the Delhi people also have a lecture specific relief act. उनका कुछ exam वगैरह चल रहा है. I had to be with them. तो आज के लिए काफी, I think you understood, isn't it? CRPC, Evidence Act, बहुत कुछ सीख लिया. कुछ पूछना है अभी about whatever we have done so far? Anybody want to ask me anything in may presume?
I don't think anyone has raised any.
बढ़ के आओ, may presume.
I'll just click.
Yeah, please read and come. May presume, shall presume, conclusive proof. These are the topic. Of course, if you understand this, half the Evidence Act will understand. Okay, that's why I'm taking pain to explain to you what exactly, how in the civil cases and criminal cases में क्या होता है, और how accomplice के evidence is led, both CPC and then CRPC. Okay, we'll stop for the day and we'll meet up, and I will tell you